The following video is intended for general information only. The circumstances of each case are different and must be addressed on a case-by-case basis. The information in this video is specific to the state of Tennessee and is not a substitute for the advice of a lawyer. Also, laws may change and may be different from county to county. Legal Aid of East Tennessee presents the Anytime Attorney, legal information on demand 24/7. This video discusses divorce in Tennessee.
The process of seeking a divorce can be very difficult to understand. Depending on your situation, you may need a lawyer's help. It is important to note that many court forms available on the internet or by using mail order will not work in Tennessee. To be sure you're using approved forms, ask your lawyer or go to www.tncourt.gov and click on Forms and Publications. These forms may be used if you don't have children. Getting a divorce can be complicated if you and your spouse have children under the age of 18 years, own real estate like a house or other property, have retirement or 401k plans, or own other valuable property. A lawyer can help you with the complex issues each of these situations present. The reason for getting a divorce is called grounds for divorce. In Tennessee, you must have one of several reasons for a divorce. One is called irreconcilable differences. If you and your spouse cannot get along anymore, but you agree on all issues in your divorce, you can file for divorce on the grounds of irreconcilable differences. Another common ground for divorce is called inappropriate marital conduct. This includes adultery, your spouse had an affair, drug abuse by your spouse, physical or mental abuse toward you, or abandonment of you. There are other grounds for divorce in Tennessee that are not as common. You should talk with an attorney about your specific situation. Where do you go to file for your divorce? In Tennessee, go to the court clerk's office in the county where you separated from your spouse, or the court clerk's office in the county where your spouse lives. You will need to ask which court hears divorce cases in your county so that you can file your papers in the correct court clerk's office. If you and your spouse separated in another state, but you have lived in Tennessee for 6 months, you can file for divorce in the county where you now live. You can also file in the county where you live if your spouse has left Tennessee or is in prison. After you have filed for divorce, your spouse must be served with the divorce papers. This is called service of process. If you don't know where your spouse is, talk with your lawyer about other possibilities for completing the service of process. If there are children from this marriage who are under the age of 18, you and your spouse must attend parent education classes. You may also be required to file a proposed parenting plan with your divorce papers. The parenting plan form is also available at www.tncourt.gov. After your spouse has been served with the divorce papers, your spouse has 30 days to file an answer with the court. If your spouse does not file within 30 days, you can ask the judge for a default judgment. This means that the judge will grant you a divorce. If your spouse files an answer with the court, your spouse will admit or deny the claims you made when you filed for divorce. Your spouse may also file divorce papers against you when he or she files an answer. This is called a counterclaim. If your spouse files a counterclaim, you will also need to file an answer to the counterclaim. If your divorce is contested, this means you and your spouse do not agree on all terms of the divorce. You or your lawyer should first try to reach an agreement with your spouse or your spouse's lawyer to settle the divorce. Mediation is the meeting of the wife and the husband and a mediator, or neutral person. This meeting may also include attorneys for both sides. The mediator talks to both the wife and husband to find out what, if any, issues can be agreed upon. If all issues are resolved at mediation, you will have a hearing in court for the judge to approve your agreement. If you can agree on issues at mediation, you will have a hearing in court for the judge to decide the issues. These issues may include shared parenting, child support, alimony, who pays the bills, and who gets the property. However, if you have an order of protection, you may not be required to attend mediation. After you file your paperwork, there is a waiting period before the court hearing. If there are no children from this marriage, you must wait at least 60 days. If there are children, you must wait at least 90 days. If your spouse fights the divorce and you cannot reach an agreement, you may have a trial. In this case, it could take several months or even a year or more to get your divorce. If your divorce is contested by your spouse and you have a trial, you will need witnesses to help tell the judge your side of the story. If your divorce is for irreconcilable differences and you and your spouse have signed an agreement, you usually will not need witnesses. If you filed a fault divorce and your spouse did not respond, you will probably need 2 witnesses. However, this may vary by county. Your witness should be able to back up your story about why you want the divorce. This witness can be a relative, friend, or neighbor who knows specific details about your situation. The other is a character witness. This person should not be related to you. He or she should know you well enough to be able to tell the judge that you are a truthful person and that you would tell the truth under oath. There are 2 different costs of a divorce: what your lawyer charges you and court costs. If you cannot afford the cost of filing for divorce, you may fill out a form called an affidavit of indigency. This is available at the court clerk's office. If your affidavit is approved, you can file your divorce papers without paying any filing fees. When the divorce is final, the judge will decide who pays the court costs. One final note: there is a 30-day appeal period after the final divorce order is filed with the clerk. You shouldn't remarry until after this appeal period is over. Remember, these have been general questions and answers about divorce procedures. Each case is different with important issues to be considered. You should talk with an attorney about the specific details of your situation.
This video was produced by Legal Aid of East Tennessee. The information in this video is not a substitute for the advice of a lawyer. Also, laws may change and may be different from county to county and in states other than Tennessee.